All right, first case is 25 CR 1492, State of Ohio versus Taryn Johnson. Ms. Smith?
Thank you, Your Honor. On behalf of Mr. Johnson is in receipt of his indictment. She has been for more than 24 hours, waives any defects in time, manner, place, or service. He is aware of the offenses for which he's charged and waives reading of the indictment as well as advisement of penalties, enters a plea of not guilty, and asks the court set the matter for a pretrial. Mr. Johnson wanted to execute his right to an in-court, but does not wish to be heard on bond.
He does not want to be heard on bond? So, Mr. Johnson, you received a copy of your indictment?
Yes, sir.
You had a chance to look that over?
Yes, sir.
You do have the right to have me read it to if you want. Would you like me to read it to you, or you can waive that if you want?
Oh, thank you.
So then, as to each of the 4 counts in this indictment, what is your plea to those 4 counts?
Not guilty.
All right, I'll enter a plea of not guilty, and bond was previously set at what? Whose case?
Your Honor, bond was set at the municipal court, $10,000 cash or surety with conditions of GPS and no firearms.
All right, well, I'll set bond at $10,000 cash surety. I'm not going to put a GPS condition on it, so just $10,000 cash surety. Was it 10% or not?
Just cash surety.
$10,000 cash surety. All right, thank you. You can call the next case. Give me 1 second, please.
Yes, Your Honor.
Ms. Smith, real quick, I don't know if Mr. Johnson was intending on posting or not, but he needs to fill this out if it's ever gonna. Oh, you have one? That was good. So you have the conditions from there, Sam? All right, then take that with that. Thank you. All right. Next case, State of Ohio versus Nakia Gray. I pronounced that correctly? Nakia?
Yes.
25 CR 1410. Ms. Smith, I'll hear from you at first.
Thank you, Your Honor. On behalf of Ms. Gray is in receipt of her indictment. She's had it for more than 24 hours and waives any defects in time, manner, or place of service. She further waives reading of the indictment and advisement as to penalties, respectfully enters a plea of not guilty, and asks to be heard on bond.
Thank you. So, Ms. Gray, you received a copy of the indictment?
Yes.
Excuse me, when did you get that, if you remember?
I got it this past Wednesday.
Okay, so a couple days ago at least?
Yes.
Okay. You do have the right to have me read it to you, as I briefly just explained to the other gentleman, but you can also waive that. Would you like me to read it to you at this time, or do you want to waive that?
Waive it.
All right. Then in regards to each of the 4 counts in your indictment, what is your plea to each of those 4 counts?
Not guilty.
I'll enter a plea of not guilty. As to bond, let me hear from the state first as to what they're seeking here. Mr. DePiro.
Your Honor, thank you, Your Honor. I have had a conversation with Ms. Smith, also the victim in this matter. These charges stem from a relationship that the defendant has with her son's father. The defendant has a 3-year-old child with a man named James Moss. He's the victim in this case. The bond was set at the municipal court at $50,000 cash surety with conditions of no contact with the victim or Bishop Park Apartments and GPS. The bind-over charges are more serious than what was actually indicted. What the bind-over was a menacing by stalking against Mr. Moss, also a trespass and a habitation.
Against Mr.
Mr. Moss being the victim.
Oh, not against him, but I mean, all right.
He's the victim.
Gotcha.
And the F4 trespass and habitation also was his apartment. Turns out the indictment's a lot different here. We have a criminal damaging. This is the defendant kicking the defendant's door, broke the frame. It was out of frustration, not an attempt to enter his apartment. But she did try to enter his apartment on another day here. That's the attempted trespass into habitation on the indictment. In speaking with the defendant is 24 years old. She has one prior misdemeanor disorderly conduct reduction in the municipal court, which was from June of this year. That also involved Mr. Moss. Other than that, she has no record. Mr. Moss was not scared of the defendant. He has no objection to her bond being reduced even to a known recognizance. He doesn't even think GPS is appropriate. He doesn't want her to come by his apartment anymore.
So why are we here right now for
Because it was a $50,000 cash surety bond, and I didn't feel that it was appropriate for us to just unilaterally change it and present you with a form to that effect, Your Honor. I wanted,
That's a first.
well, if I was the judge, that's what I'd want. So that's why. So we have an agreement here in terms of the state would not object to an own recognizance bond in this matter with the conditions of no contact
With Bishop Park Apartments or the defendant,
Mr.
or the
Moss.
victim.
But Mr. Moss did say that he does want to be able to communicate over the phone about the child.
Well,
But I told him
that's going to be too much of a. That's going to have to wait until this gets resolved.
Yes, Your Honor. So
I'm assuming you're good with that bond? Or-
Yes, we have no objection to the owner recognizance bond or the no contact order.
Okay. Well, I'm going to set bond then, reset bond at the defendant's own recognizance with the condition that you have no contact with Bishop Park Apartments and no contact with Mr. Moss. And that means you can't contact him about your child either. And I know that may be an issue now, but I can't say except for these circumstances because then it can never be monitored or policed. So while this is pending, that's going to have to be the rule. You understand that?
Yes.
And we've reduced your bond substantially, but if you violate that, I'm not going to hesitate to revoke it. If we find out that you reached out to him, and even if you come up and say, well, I found out something about my daughter and I had to talk to him, that's not going to be an excuse. There's no excuses here. You understand that?
Yes.
All right. And then bond will be reset at defendant's own recognizance with the condition of no contact at Bishop Park Apartments and no contact with the victim, Mr. Moss. She fill out paperwork? You got one filled out there for
We
her?
have conditions of bond, we do not have the owner recognizance paperwork.
I have OR paperwork, Your Honor. I will give that to Ms. Smith right now.
Stan, can you witness? Right. So the important
Now you're
thing to
gonna
know
witness,
about
Stan?
this is when you're released on an owner recognizance bond, even though you don't have to post any money, if you fail to appear because it was on your words, it's a felony as a 4th degree. So you'd actually be in more trouble if you didn't come to court than you could be for what you're charged with here, okay? So as long as you understand that, sign your name.
He's gonna do it right here. We're gonna fill out the paper stuff there.
Sorry.
Good.
Did I fill out the
Yep.
rest?
Smith, you said you had conditions of bond form filled out already?
I do as well as the trial waiver.
What county is Bedford? Is that Cuyahoga County?
That is.
I'm going to put that up here too. Then. That's where you're going to be residing in Bedford?
Yes.
She can't go over there. She can't understand.
Yes.
So this OR bond, Ms. Gray, means you have to show up at all future court dates. And if you fail to appear at a future court date, that's a separate felony that you can be prosecuted for. It's actually more serious than anything you're charged with here right now. And you can get up to 18 months in prison on that, which could be consecutive to anything that could happen with any of these charges. So it's obviously, or at least the felony. So it's obviously important you show up at all your future court dates. You understand that?
Yes.
All right. All right. Very good.
Thank you.
You can take off, Rob, if you want.
What's that, Judge?
You can take off if you want.
Thank you, Your Honor.
All right, last case for now. State of Ohio versus Lavelle Vincent, 25 CR 1312. Ms. Smith?
Thank you, Your Honor. On behalf of Mr. Vincent, he is in receipt of his indictment and has been for more than 24 hours. Waives any defects in time, manner, place, or service. Waives reading of the indictment as well as advisement as to penalties. Respectfully enters a plea of not guilty and asks to be cleared on bond.
All right. Mr. Vincent, you received a copy of your indictment?
Yes, sir.
When did you get that, sir?
Today.
Okay. So they attempted to serve it, I think, earlier, last week maybe, and then you got a notice and you came in today?
Yes, the address that y'all had on file for me was 2 years old, so I didn't get the original copy.
How did you know that this was scheduled for today?
Well, I had corresponded with my public
Right.
defender.
Okay. But you received a copy of the indictment?
Yes, sir.
I could read it to you if you'd like, or you can waive the reading. What would you prefer at this time?
You can waive it, sir.
Very well, then, and you're charged with the one count of failure to comply with an order or signal of a police officer, felony of the third degree. What is your plea to that count at this time?
Not guilty.
All right, I will enter a plea of not guilty to the charge. Let me start with the state on the matter of bond. Ms.
Thank you, Your Honor. Just to clarify, originally, this wasn't set for arraignment today. It was set for October 31st. He was attempted to be served on October 21st. Came back bad address. He did not appear on October 31st for the arraignment. I was contacted last Friday that he wanted to turn himself in on it. I called Ms. Smith back to ask a couple questions. I didn't hear back. The information I have is that it was a bad address. That is the address that is on the clerk's website, and my understanding that he has been using. In addition, part of the bond conditions, the bond at a Willoughby Municipal Court was $25,000 cash surety or 10% with no driving. Initially, it had GPS on it. GPS was then stated to be removed for Lake County because he was on GPS in Cuyahoga County, but the order was that if Cuyahoga County removed their GPS, defendant had to go to the Lake County Probation Department within 24 hours to have GPS put on for this case. I contacted Chief Probation Officer Craig Berry to find out if he was aware of GPS. Initially, he said no, that he didn't believe he was on GPS. He followed up and learned that Cuyahoga County had removed the GPS, and that though the defendant did not go to Lake County Probation Department and have it put on, he did have it put on by On Track. Just Lake County Probation had no idea. So he is on probation in 2 different cases in Cuyahoga County. The reason the GPS was put on in September 2025 was for a probation violation for failing to report. In addition, just looking at the factors, when we look at bail for the seriousness, for this case, there were multiple traffic violations, including speeds over 120 miles per hour during this failure to comply. Around 3:30 in the morning, there were other vehicles as well as semi-truck on the road. Defendant does have a criminal history. He went to DYS as a juvenile for an assault in 2003 as an adult. In 2009, he has 3 different cases with convictions: felony DV, attempted robbery F3, domestic violence F4, a burglary F2, and another DV F4. The first domestic violence, he had probation and then had a violation. He did have.
No, we're not here for sentencing right now.
Right, but part of the factors they do talk about the prior criminal history. So I did want the court to know he has additional felonies in 2015 that he went to prison. In 2017, he has misdemeanors. And then he's on probation for a 2022 case in trafficking in drugs and a 2023 case for domestic violence. There is on his leads a reference to a failure to appear warrant in 2020. He's not able to determine where that came from, and then he didn't show for his arraignment and obviously the failure to report. So we did ask for an increase in his bond to $50,000 cash surety or 10% with conditions of no driving and GPS.
All right. Smith?
Thank you, Your Honor. On behalf of Mr. Vincent, Mr. Vincent posted a $25,000 10% bond out of Willoughby Municipal Court back in September on this matter. He has been out on bond without further issue. He's had no further violations of his probation. He is on supervision to Cuyahoga County and reporting regularly. Additionally, Your Honor, Mr. Vincent did not fail to appear before this court for his arraignment when it was first set in a deliberate or willful manner. That was simply because he had not received service.
Why didn't you receive service?
Because it was sent to a bad address.
It was sent to the address that he used off the municipal court. I mean, we didn't just come up with this address. We got it from him.
Address that.
I mean, that's in all the paperwork that he filed, that he signed. That the address is there. So,
It's the address that's on his driver's license.
where did you think stuff would get sent it then? I mean, we're supposed to know where you're really living?
No,
The court pre-populated the information.
All right. Where's this? He didn't give another address. He didn't provide an address. How is he supposed to be notified?
I say something.
I don't know who wants to talk, but
Mr. Vincent reached out to counsel as soon as he learned of the warrant and indictment, and counsel reached
I
out.
get it. But he signed the paperwork saying this was his address. Now, maybe it was pre-populated at the Willoughby Municipal Court, but he represented by signing it that was his address. He could have crossed that out and said, "That's not where I live. You're not going to be able to get a hold of me if you try to reach me at this address."
So at that time, I probably didn't look over the paperwork proper, but like since then, I've been on GPS for you guys. So it wasn't like I tried to run from the course or nothing.
I understand that, but we need to have an address of where you're living, and you didn't provide that.
And Mr. Vincent has completed a conditions of bond
Well,
form.
today,
with
I mean-
with a current address. Additionally, he turned himself in upon learning of the warrant, and after counsel spoke with the state. Your Honor, we would ask that his original bond be continued at $25,000, 10%. We don't object to the GPS if the court feels that it's warranted to protect the public safety. However, it does create a financial burden for Mr. Vincent, and if the court is satisfied with his lack of violations since September, we would ask that it be removed.
All right, Mr. Vincent, if you're given a bond, you have to keep the court updated as to where you're living. And you could change. I'm not saying you can't change it, but as soon as it changes, you need to notify your lawyer, and so the courts can be notified, because we have to notify you by notifying, sending stuff to the address that you provide for us.
Yes, sir.
We're not mind readers. We don't know, that you don't live at the address that's on there. And I'm not saying it's unusual that someone's address on their license, they live somewhere different from that. Obviously, that happens. But you need to keep us updated. If you move, 1 month and then you move somewhere else you're living, you need to let us know that. And if you don't, it's going to be a violation of your bond. You understand that?
Yes, sir.
All right. Court's going to reset bond at $25,000 cash surety or 10%. Anything else for the record?
Not at this time, Your Honor.
Ms. Cutts?
Your Honor, we'd ask at least for the no driving as a condition.
Yeah, you're not to drive. You're not to drive.
I
As a
know.
condition of your bond as well. I didn't hear that. If you said that, I missed that. Sorry.
It was no driving in GPS.
Well, I'm eliminating the GPS requirement, but I'm keeping the no driving condition.
GPS will come off, but no driving.
Okay.
At least in Lake County. I don't know if there's GPS somewhere else. I have no authority to do anything about that. And do we have a conditions form?
Conditions and speedy trial.
All right, here, Stan, you can put that with that.
Yes, sir.
All right, anything else, Ms. Cutts?
Not at this time.
Ms. Smith?
Oh, not at this time.
Oh, you answered. All
I
right.
answered.
All right, thank you.
All rise.
here this morning, the State of Ohio versus John S. Penland, case number 25 CR 838. The defendant is present in open court with their attorney, Mr. Mulkey. We are here today for a change of plea. The defendant is charged with one count of theft, a felony of the 5th degree. State's understanding that he will enter a plea of guilty today. There is no agreement at this time as to sentencing.
Thank you. Mr. Mulkey, is that accurate?
It is, Your Honor.
Were you able to hear what the prosecutor just had to say regarding what she believes your intentions are here at this time?
No, Your Honor.
You didn't hear what she just said?
Oh, yes. Yes, I did.
She indicated to the court she believes it's your desire to withdraw your previously entered plea of not guilty and plead guilty to the charge in this indictment. We would then continue the sentencing to a later day to get some evaluations completed, come back on a future day for sentencing where there's no agreement between the parties regarding any recommendations for sentencing. Each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor and what you want to do today?
Yes, Your Honor.
Well, before I can accept your plea, I need to make sure you understand everything going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you have that you give up by pleading guilty, as well as other possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you any of these questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask him questions, or if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes.
All right. Let's get started then. How old are you?
22.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that, or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about in the last 48 hours?
No.
Not even prescribed medication, nothing?
No.
Now, did you receive, I know you did, you should have received a copy of the indictment in this case. Looks like you got it sometime around the middle of September. That's the document that sets forth the specific charge you're accused of committing. Do you remember getting that?
Yes, Your Honor.
And did you have the chance at some point to look that over?
Yes.
Now, in that indictment, what's alleged here and what you'll be admitting to is on or about September 19th of 2024 in Willoughby, Lake County, Ohio, that you did with purpose to deprive Lowe's Home Improvement, the owner of certain property, that being miscellaneous merchandise, that you knowingly obtained or exerted control over that property without the consent of Lowe's Home Improvement, who is the owner of that property, or anyone else that's authorized to give consent. It's further alleged the value of that property was over $1,000, which makes the offense theft, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions for me about it?
No.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up by pleading guilty. And you, first of all, do have the right to have a trial in this case. That trial could be to me as a judge, where I listen to the evidence and I make that ultimate decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And a jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then the jurors would make that ultimate decision. That ultimate decision reached by the jurors would have to be a unanimous decision, which means all 12 of the jurors would have to agree together, one way or the other, guilty or not guilty. All 12 would have to agree, and before there could be a verdict. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes.
Now, if we did have a trial, the prosecutor here would be representing the state of Ohio, and she would have what we refer to as the burden of proof. Now, with her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility, she bears the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of this charge. That presumption of innocence sticks with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it actually means It's the amounts of the evidence and the quality of that evidence that the state would have to present before you could ever be found guilty of the charge. You understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt of this charge?
I didn't hear you. Can you repeat that?
Do you understand that by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt of this charge?
Yes.
Now, in order to try to do that, if we were going to have a trial, the prosecutor would bring witnesses into the courtroom to testify for the state, and they'd answer questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. He could ask them anything he wanted to within certain rules. Do you understand that?
Yes.
You understand by pleading guilty, you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that, but you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. That order is called a subpoena. And what a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they were not willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That's a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's your choice, what that really means then is that nobody else can force you or make you. You all right?
Yes.
All right. You were looking around here. You're able to focus on what's going on?
Yeah, I am. I'm here.
All right. The fact that it's your choice that you have to make means that nobody else can force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. More importantly, the prosecutor here is now allowed to call you as a witness, make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
You further understand that if you went to trial and you were found guilty, you would have the right to appeal or challenge that guilty finding to another court, a higher court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes.
All right, well, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No.
Do you understand them all?
Yes.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt. It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is you'll be found guilty by the court, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the 5th degree. This offense is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes.
Now, are you currently on probation or parole to any of the courts or agencies?
Can you repeat that?
Are you on probation or parole, any type of supervision to any other courts or any other...
Yes. Portage County.
Portage County?
Yes.
You're what, on probation?
I'm on probation.
Okay.
Yes.
Were you on probation when this happened?
No.
Okay, so that's what just recently you were put on probation, what, a couple weeks ago?
Huh? Yes.
Were you on probation anywhere when this happened?
No.
Okay. Do you have any other charges pending against you right now that haven't been resolved?
No.
Okay. If a prison sentence is imposed in this case upon your release from prison, you could be placed in what's called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. In this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you are on post-release control and you ever violated any of the conditions of your supervision, the parole authority could send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by this court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence, there's other sanctions that could be ordered. You could be fined, in this case, up to $2,500. You could be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment, if any that were applicable in this case. Do you understand that?
Yes.
You could also be ordered to pay restitution to the victim for any economic loss any victim may have suffered as a result of your conduct. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence. I used the word possible because prison is not mandatory with this charge. You are eligible for probation or what we call community control sanctions. Do you understand that?
Yes.
Do you understand that just because you're eligible doesn't mean you'll automatically be put on community control? It means I will consider that if that's what you're asking for. I'm going to look at all the information that gets presented. Then I'll make the decision that I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control, it could be up to 5 years of supervision. And as the judge, I do have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve time in our Lake County Jail of up to 6 months, the condition of probation. Do you understand that?
Yes.
Further, if you're on probation in this court and you ever violate any of the conditions of your probation, we would have a hearing here in court to see if you're what's called a probation violator. And if it was determined that you were, I could extend your probation up to 5 years. If it wasn't originally 5 years, I could impose more restrictive sanctions against you, including jail time, or I could terminate your probation and send you to prison at that point. If I sent you then, again, it could be 6 to 12 months in prison, and that could be consecutive to any other sentence you may be serving at that time or you're being sentenced to at that time. Do you understand that?
Yes, Your Honor.
Lastly, when we do come back here for sentencing, you'll have the right at that time to say anything you want me to know or consider. Your lawyer can speak on your behalf. He can recommend the sentence to the court. The prosecutor is allowed to recommend the sentence to the court as well. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes, Your Honor.
All right, then. Well, do you have any questions at all regarding the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your lawyer, have him review the report with you, discuss the issues, and answer whatever questions you may have?
Yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes.
Excuse me. Has he or has anyone made any promises to you about what's going to happen at sentencing which is inducing you to plead guilty?
No.
Are you entering your guilty plea freely and voluntarily?
Yes.
All right, then. Do you have any questions for me at this point regarding anything we've just talked about? The rights you're giving up, penalties you face, what you're pleading guilty to? Any questions at all?
No, Your Honor.
Do you need any more time to speak to your lawyer?
No.
All right, then what we're going to do at this point, the prosecutor here is going to explain for me what she believes the evidence would show if we had a trial. I want you to listen to her because I got some follow-up questions for you, all right?
Yes.
All right. Ms. Cantor.
Thank you, Your Honor. The evidence would have shown that on September 19th of 2024, the defendant did enter into the Lowe's in Willoughby, Lake County, Ohio. Between the defendant and the co-defendant in this case, items were selected from different aisles, put onto a cart. They were in the store for some time. The defendant did ultimately push that cart with all of the items past the point of sale without paying for any of them. They totaled $2,088.85.
What was the total?
$2,088.85.
Thank you. Were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes.
What, if anything, you have to say about those facts as she presented them? Are they accurate? Did you do what she said?
Yes.
Very well then, regarding count 1, charging you with theft of felony of the 5th degree, what is your plea to that count?
Guilty.
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just explained to you. Before I can accept your plea, I need to make sure you understand this argument. I need to make sure you understand the document, what it says in the contents of the pages, and that you sign it here in open court. My understanding is before I walked out here, you had a chance to go over this document with your lawyer, though. Is that correct?
Yes.
Smokey, is that accurate? Did you read this over with your client, review it, answer all the questions?
Yes, Your Honor.
Did she indicate an understanding of the document?
Yes, Your Honor.
Is that true? You understand the document?
Yes,
You
Your
went
Honor.
over it?
Yes.
Do you have any questions for me about it?
No.
It also appears you signed it. Did you sign it?
Yes.
And did you witness that, Mr. Mulkey?
I did.
Ms. Cantor?
I did, Your Honor.
Very well, then let the record reflect the defendant was here in open court. The lawyer advised of all our constitutional rights, made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count 1, theft of felony of the 5th degree, violation of 2913.02A1. The first sentencing, order of pre-sentence report and investigation, and a victim impact statement. Any other evaluations or anything else you're requesting, Mr. Mulkey?
No, Your Honor.
All right, so then the victim impact statement and PSR. Bond was previously revoked. Did you want to be heard on that matter?
I do, Your Honor, please.
Go ahead.
Thank you, Your Honor. Your Honor, my client, the address is 6817 Hosmer Avenue in Cleveland, 44105. My client resides there with his mother, Anisha Ponder. My client is set to start a job on Monday at Rich Boys Tires in Cleveland. As it relates to why bond was revoked, my client was late to court, understands the consequences for that, has seen what happens when you come late to court, was being driven by his mother to court on that date. I just want to note for the court that at the time of the pretrial that we had, my client was also required to be in Portage at that same time, came here first, made every effort to show up for court for the pretrial, was here late last time, laments the fact that he was late to court, and would ask the court to consider reinstating that bond, trying to maintain his probation, follow the court's orders in Portage County, resolve this case here, take responsibility for that one, understands that he needs to appear for sentencing and for a pre-sentence report. Will follow all the court's bond conditions as previously set, will not test positive for any substances, will complete the PSR and follow any and all other bond conditions, Your Honor. So I would ask the court to take all that into consideration. Mr. Penland's been an excellent client, maintained contact with me throughout the duration of my representation, again, including the need to be in Portage and here for the pretrial, was able to accomplish both of those things. Was a few hours late for court in Portage as a result of coming here first, but was able to work everything out and wants to do so and demonstrate to this court that he can do that again. Thank you, Your Honor.
Stay in position on bond.
Your Honor, the only thing that I know about the defendant is based on the history. They were just put on probation several weeks ago. They do have one prior felony conviction for the same type of theft in Geauga from March of this year. Other than that, no history. And as with regards to the ability to show up, they did come to the pretrial and were an hour late for the change of plea. Other than that, I have no position.
Well, the reason the bond was revoked was because you weren't here when it was scheduled. I know you called. You said you were running an hour late. This is not an open house. We're just not open from 8 to 4. You can show up whenever you want to show up. You were scheduled to be here at a certain time, and that's the time you were supposed to be here. We have other hearings scheduled throughout the day. If you don't show up when you're supposed to, and then I'm supposed to wait an hour for you to get here and do the next hearing, and the hearing that's scheduled for when you're supposed to go has got to be pushed back, and so forth, and then we all have to stay here late, and everybody else has to sit around and wait because you didn't get here when you were supposed to get here. That's not how it works.
I know, Your Honor. I apologize for me being late, but I had things that I was trying to put in order for making sure I was here, but there's no reason.
You didn't do it. You didn't do whatever you were supposed to be doing, apparently.
But
So you need to try a little harder. You need to do whatever you need to do. If it's too early in the morning, then you need to get here the night before.
Right.
And do whatever you have to do. But there's no explanations for that. I mean, but you did show up. And I'm going to reinstate your bond because of that. Hopefully the 3 days, 3 days you sat in jail shows you the importance of being here on time. It's not going to happen again. If you don't show up when you're supposed to, even if you're late, your bond's getting revoked and you're just going to sit and we're going to wait until the next hearing. You understand that?
Yes.
All right, so I'll reinstate your bond at $5,000 cash surety, no contact with Lowe's. So you're going to get out of here sometime today. It won't be immediately. They have to do paperwork to get you out, but you're going to get released here shortly.
Yes.
When you get released, you need to immediately go to the probation department, which is, you know where that is?
No, if I can get the address from my...
Well, it's in the same building you're in. You don't even have to walk outside.
Okay.
You're going to come down one side of the jail. You're going to walk across, and then there's elevators right by the front doors. You're going to take that up to the 3rd floor.
Okay.
That's the probation department, so you won't even have to leave the jail. They're going to have paperwork. They're going to be expecting you there. Make sure you go there. If you don't go there, they're going to let me know that, and then I'm going to have to issue a warrant for you again. So go there as soon as you get released from the jail. You're going to fill out some initial paperwork, and then you're going to get a date that you have to go back there for your interview. They need to, they're going to be completing a pre-sentence report. In order for them to complete a report, they have to sit down with you and interview you and talk to you. If they can't do that, if they're not able to do that, then they can't do a report. If there's no report, I'm not even allowed to consider probation as an option. I'll have to send you to prison. So it's important that you show up, not just today, but then when you're there today, you're going to fill out some paperwork and you're going to get the date to come back there for your interview. They're not going to be able to do the interview today. It takes a couple hours, so make sure you have some time. But if you don't show up for that interview, then they can't complete a report. And without a report, I have to send you to prison. You understand that?
Yes.
All right. Also, a condition of your bond has been and will continue to be that you don't use any drugs. Is drugs an issue at all? Are drugs
No.
an issue? If
No.
they are, you should let us know so we can explore that to make sure that that's an issue that needs to be addressed.
No.
All right, well, they may take urine screens from you. They have to be negative. A positive screen will, again, automatically result in your bond being revoked and a warrant being issued. You understand that?
Yes.
Okay. So what are you going to do when you get released today?
Go to probation.
All right. And then you're going to get a date to come back, and then you come back whenever you guys work out that
Yes.
date. All right. Standing out, I'll sign paperwork from him. All right, anything else,
Nothing further.
Mr. Mulkey?
Nothing, Your Honor.
All right,
Thank you.
thank you.
Thank you, Your Honor. To please the court, we're before the court this afternoon in the matter of the State of Ohio versus Margaret Kotkowski, case number 24 CR 068. The defendant is present in the courtroom. Her attorney, Nicolette Tomaszek. We're before the court for purposes of a change of plea. It is my understanding the defendant wishes to withdraw her previously entered pleas of not guilty and plead guilty to the indictment. That be all three counts and the forfeiture specification attached to count one. Parties are ready to go forward.
Is there any discussion with defense counsel regarding any recommended sentences?
No, Your Honor. The state is not committed to recommend one sentence or another. The state has said that it would consider the defendant pleaded guilty here, but there's no agreement or no commitments.
Thank you. Ms. Tomaszek, does that all sound accurate?
Yes, Your Honor, that is my understanding today.
And Ms. Kotkowski, were you able to hear what the prosecutor had to say regarding what he believes your intentions are here today?
Yes.
He indicated to the court he believes it's your desire to withdraw your previously entered pleas of not guilty and plead guilty to the three charges in the indictment, and I'll go over those with you to make sure you understand them. We would then continue the sentencing to a later day to get some evaluations completed, come back on a future day for sentencing. Where there's no agreement between the parties regarding any recommendations for sentencing, each side is free to recommend to the court whatever sentence they believe is the right thing to do. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, more importantly, what you want to do today?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what it is you're charged with and pleading guilty to, the rights you had that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you the questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer to ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right? You have to say yes or no.
Yes.
Thank you. All right, let's get started then. How old are you?
33.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No. Prescription medication.
Well, that's my next question, on whether you're taking any, even taking any prescribed medication. So you've had some prescribed medication within the last 48 hours?
Yes.
What would that be?
For high blood pressure and anxiety.
So just the two medications?
Yes.
When's the last time you had those?
This morning.
Do either of those medications affect your ability to understand or appreciate where you are or what's going on around you or anything like that?
No.
So you're not under the influence of either of those medications right now in a negative way, which is negatively impacting you in any manner?
No.
All right. Now, you would have received a copy of the indictment in this case. It looks like you got it back last spring, some around the beginning of April of not last year, but this year, but this past spring. You remember getting that document at some point?
Yes.
And had a chance to look that over at some point?
Yes.
Now, in that indictment, you're charged with 3 counts. Count 1, and you're pleading guilty to all 3 of these counts. Count 1, it's alleged, and what you'll be admitting to is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use cocaine or some compound mixture, preparation, or substance which contained cocaine. The amount involved did not equal or exceed 5 grams, which makes the offense possession of cocaine a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 1?
Yes.
Any questions about that for me?
No.
Now, count 1 also carries with it what's called a forfeiture specification, which alleges that you possessed or had an interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just by the nature of the property itself, like drugs. An instrumentality is some type of property that there may not be anything illegal about it in and of itself, but it's being used in an illegal manner to facilitate a crime, and you can't use or possess it for that purpose. And here it's alleged that all the drugs, the paraphernalia, and the instruments confiscated are considered to be instrumentalities or contraband. The whole point of this is that you forfeit any ownership interest you have in any of that property. It allows the state to be able to dispose of that property at the end of the case. It doesn't increase any potential penalty you face, except that you lose your ownership interest in it. Do you understand that?
Yes.
Any questions about that? Now, in count 2, what's alleged here and what you're admitting to is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use a fentanyl-related compound or any compound mixture, preparation, or substance containing a fentanyl-related compound. The amount involved did not equal or exceed 1 gram, which makes the offense possession of the fentanyl-related compound a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes.
Any questions about that for me? Lastly, in count 3, what's alleged here is on or about April 13th, 2021, in Mentor Lake County, Ohio, that you did knowingly obtain, possess, or use alprazolam, diazepam, clonazepam, and zolpidem, or any compound mixture, preparation, or substance containing those drugs. Those are a Schedule 4 controlled substance. It's further alleged that the amount of those drugs did not equal or exceed the bulk amount for those drugs, but that you have previously been convicted of a drug abuse offense, being drug possession in Cuyahoga County, and or possession of a drug abuse instrument in Rocky River. That conduct, along with the prior convictions, constitutes the offense of possession of drugs. It's a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in regards to count 3?
Yes.
Any questions about that for me?
No.
So you understand the nature of the 3 charges you're pleading guilty to?
Yes.
Well, then before I can accept your guilty plea, I need to make sure you understand all the rights you are giving up. And you first of all have a right to a trial. Now, a trial could be to me as a judge, where I listen to all the evidence and I make that decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be unanimous. That means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty of each individual charge. You understand that?
Yes.
You understand by pleading guilty or giving up your right to have a trial in this case?
Yes.
Now, if we had a trial, the prosecutor here would be representing the state of Ohio. He would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it is his job, or he bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You're presumed innocent of all these charges, and that presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of all these charges beyond a reasonable doubt before you could ever be found guilty of any of these charges. Do you understand that?
Yes.
You understand by pleading guilty or giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt of these charges?
Yeah.
Now, in order to try to do that, if we were going to have a trial in this case, the prosecutor would be bringing witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions. That's called cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes.
Do you understand by pleading guilty or giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you want to. Do you understand that?
Yes.
And you further can request the court issue an order. We call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if they weren't willing to come in voluntarily on their own. Do you understand that?
Yes.
Do you realize you're giving up that right?
Yes.
Now, you also right at a trial, you could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you and you alone would have to make. Do you understand that?
Yes.
So what that really means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But more importantly, the prosecutor here, he's not allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Do you further understand that if we went to trial and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions? By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. The court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Can you say that again?
Yeah, looked like you had a question about that. By pleading guilty, you're giving up your right to appeal a guilty finding. So if I accept your plea of guilty, I'm going to find you guilty. You're not going to be able to appeal that or challenge that at a later time. You're also not going to be permitted to appeal any issues that have been raised so far that you disagree with the ruling on, if there is any, or that you could have raised but you haven't so far, but you were able to. You're not going to be able to raise those later. Do you understand that?
Yes.
You have questions about that? You want to talk to your lawyer about that? Or you can ask me, whatever you want to do, but
Can I
want a
have a
minute to
moment,
talk to your lawyer? Go ahead.
What?
Ready to proceed, Your Honor.
Do you have any questions for me at this point? Are you ready to continue?
Yes.
All right. So do you understand what I just explained to you then about the giving up your right to appeal any issues that you could have raised so far or finding it guilty?
Yes.
Okay. All right, then do you understand all the rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. Do you understand them all?
Yes.
Do you still want to plead guilty?
Yes.
Do you understand a guilty plea is a complete admission of guilt? So it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue at any later time that you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you will be found guilty by the court of these charges, and then you will subsequently, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to 3 felonies of the 5th degree. Each of these are punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes.
Now, since there's 3 charges here, if a prison sentence is imposed, I would impose a prison term on each count. And then as the judge, I have the discretion to run those prison terms either concurrent or consecutive to each other. Concurrent means together at the same time. You'd serve those terms at the same time. Whereas consecutive means one after the other. You'd serve the prison term for the first count, finish it, whatever it is, then the second count, and then so forth. Do you understand the difference there?
Yes.
So in this particular case, if I impose the maximum sentence on each count and ran them each consecutive, you're looking at a maximum possible prison term in this case of 36 months or 3 years in prison. Do you understand that?
Yes.
Now, are you currently on probation or parole or any type of supervision with any of their courts or agencies?
No.
Do you have any other criminal charges pending against you anywhere?
No.
If a prison sentence is imposed in this case, upon your release from prison, you could be put on what is called post-release control. It's sometimes referred to as parole. It's a period of supervision you would be on after, I'm sorry, after you completed your prison sentence. And in this particular case, it could be up to 2 years. Do you understand that?
Yes.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you committed, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes.
All right, now in addition to the possible prison term that I just explained to you, there's other sanctions or penalties that could be ordered. You could be fined in this case. Each of these counts carries with it a possible fine of up to $2,500. So altogether, that's a maximum possible fine of $7,500. I could order that you pay court costs. I could also order that you reimburse the county for any costs of confinement, community supervision, or treatment, if any that were applicable. Do you understand that?
Yes.
I could also suspend your driver's license for up to 5 years. Do you understand that?
Yes.
And lastly, as I alluded to a little earlier, any right, title, or interest you have in any of that property that's in the forfeiture specification will be forfeited to the state of Ohio. Do you understand that?
Yes.
Now, a few moments ago, I explained the possible prison sentence. When I did that, I used the word possible. Prison's not mandatory with any of these charges. You are eligible for probation, or what we call community control sanctions. Do you understand that?
Yes.
Now, do you understand that just because you're eligible doesn't mean you'll automatically be put on probation? It means I'll consider that if that's what you're asking for. I'm going to look at all the information presented. Then I make the decision I thought was the right thing to do. Do you understand that?
Yes.
Now, if you are put on probation, it could be for up to 5 years. And as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. You understand that?
Yes.
Further, if you are on probation, excuse me, and you ever violated any of the rules or conditions of your supervision, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could order more restrictive sanctions against you, including an order that you serve time in our county jail. Or I could terminate your probation and send you to prison at that point. And if I did it at that point, again, it could be 6 to 12 months in each count. I could run all those consecutive for 36 months in prison. And that could also be consecutive to any other prison sentence you may be serving on some other case, if there's a new case that you pick up or that you're being sentenced to at that time if there's some new case. You understand that?
Yes.
Lastly, when we do come back here for sentencing, you'll have the right on that day to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I don't have to follow that if I didn't think that was the right thing to do. Do you understand that?
Yes.
All right, well, do you have any questions at all about the potential penalties you face by pleading guilty here today?
No.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to talk about this case with your lawyer and have her go over everything with you and answer your questions?
Yes.
Are you satisfied with her advice and counsel?
Yes.
Has she, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty today?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Are you entering this guilty plea freely and voluntarily?
Yes.
All right, then, do you have any questions for me at this point regarding anything we just talked about? What you're pleading guilty to, the rights you have, any of the penalties you face? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with your change of plea?
No.
All right, then what we're going to do at this point, the prosecutor here is going to explain for me what he believes the facts would show if we had a trial. I want you to listen to him, because I'll have some questions for you about that then, all right? Mr. Shapiro.
Thank you, Your Honor. The evidence would show April 13, 2021, in the city of Mentor, Lake County, Ohio. Mentor Police Department received a call about an unresponsive female in an Uber ride share. Police responded to the address of the caller. It was on the street in front of a home in the city of Mentor. They found the defendant to be in the back seat of that car, unresponsive, administered Narcan. She came to. She was the only occupant of the vehicle other than the driver. She had some property in the car, the defendant did, and amongst that property there's a purse that contained drugs, specifically cocaine in an amount less than 5 grams in a sealed envelope. Also, there was fentanyl, and that cocaine is Schedule 2, is confirmed by the crime lab. Also, fentanyl was also in another sealed envelope in that purse, Schedule 2 controlled substance, confirmed by the crime lab. And there were a number of pills also in a pill bottle, and that was alprazolam, diazepam, clonazepam, and zolpidem, all Schedule 4 controlled substances, confirmed by the crime lab. And the defendant at that time had been convicted of a drug abuse offense as enumerated in Count 3 of the indictment. The state incorporates into its oral recitation of the facts right here, the specifics of those. And that's it, Judge.
Thank you. So were you able to hear what the prosecutor just had to say?
Yes. Yes.
Were you able to hear what the prosecutor just had to say regarding what he believes the facts would show if we had a trial?
Yes.
What, if anything, do you have to say about those facts as he just presented them? Are they true? Did you do what he said?
Yes.
Very well, then regarding count 1, charging you with possession of cocaine with the forfeiture specification of felony to the 5th degree, what is your plea to that?
Guilty.
Regarding count 2, charging with possession of a fentanyl-related compound of felony to the 5th degree, what is your plea to that?
Guilty.
And regarding count 3, charging with possession of drugs of felony to the 5th degree, what is your plea to that?
Guilty.
All right, I have in my possession here a 4-page document called a written plea of guilty and judgment entry, which explains everything I've just gone over with you. Before I can accept your plea, I need to make sure you understand this document. Excuse me. And that you sign it here in an open court. Now, my understanding is before I came out here, you had a chance to go over this document with your lawyer. Is that correct?
Yes.
Ms. Tomaszek, is that accurate? Did you read this over with your client, review it with her, answer her questions?
Yes, Your Honor.
Did she indicate an understanding of it to you when you did that?
She did, Your Honor.
Is that correct?
Yes.
So you understand what the document says?
Yes.
Do you have any questions for me about it?
No.
Now, it also appears you signed this document. Did you sign it before I came out here?
Yes.
Can you witness that, Ms. Tomaszek?
Yes, Your Honor.
Mr. DePiro, you as well?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer, with her lawyer, advised of all our constitutional rights and made a knowing, intelligent, voluntary waiver of those rights. The court also finds the defendant understands the nature of the charges, the effect of the guilty pleas, as well as the maximum penalties that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's pleas. Find the defendant guilty of count 1, possession of cocaine, a felony to the 5th degree, in violation of 292511 of the revised code with the forfeiture specification. Count 2, possession of a fentanyl-related compound, also a felony to the 5th degree, in violation of 292511. And count 3, possession of drugs, a felony to the 5th degree, in violation of 292511. I will defer sentencing, order a pre-sentence report and investigation, drug and alcohol evaluation, and bond will remain revoked. Is there anything else for the record at this time, Mr. DePiro?
No, Your Honor. Thank you.
Ms. Tomaszek.
No, Your Honor. Thank you.
Thank you.
All rise.
Excuse me. All right, we are present in case 25 CV 935, Trimbath versus Nassan, N-A-S-S-A-N. We're scheduled for a damage hearing this afternoon. Plaintiff, what is your name, sir?
Joshua Trimbath.
Joshua Trimbath is present. Are you representing yourself in this matter?
Yes, I am.
There's another plaintiff as well, correct?
Yes, that is my wife. She's at home getting the kids off the bus. I apologize. She was not able to make it.
Okay. All right. So Mr. Trimbath is here representing himself in this matter, and nobody is here on behalf of the defendants. So we previously granted default in the schedule. So the default judgment was previously granted, and we scheduled it for a damage hearing to give Mr. Trimbath an opportunity to present whatever evidence he wants the court to consider in determining an award of damages. So, Mr. Trimbath, I'll turn it over to you at this point. I'll just place you on the oath before we get started here so that anything you say will be obviously under oath. So please stand for a moment and raise your right hand. Do you swear or affirm that any testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, you may be seated. And I'll turn it over to you. Go ahead and let me know what you want me to say, whatever you want me to know.
So I have a list and all receipts for pretty much everything I've spent rehabbing the house and missed payments that have happened, as well as missed time of work to rehab the house. And then I have the pictures of where the house was left back in March of 2024 when they vacated the premises.
Let's start with the missed rental payments, the damages pursuant right to the contract there in regards to the lease, the rental payments.
Okay, so they had missed 2 payments back in 2022 because of, I'm not 100% sure exactly why, but they were supposed to buy the house, so I told them that.
Were those payments part of this lawsuit?
Yes.
Okay. How much were those?
I told them that we could put those at the very end and make it as part of buying it, and then obviously they stopped paying in December of 2023. They were evicted in March of 2024.
So the last payment you would have received would have been November of 23?
Yes. Well, I received November's payment in December.
All right, but you received the payment for November?
Yes.
So you haven't received a payment from December of 23 until when then? When were they?
I asked them to vacate the premises on March 3rd or March 10th. I have the
Of 24?
Of 2024, correct. March 10th, 2024 is when I hung the eviction on their door.
How long was the term of the lease?
The term of the lease was a 12-month lease, and then it was month-to-month afterwards. The lease started in March of 2022.
So at the point where they were in default, it was month to month at that point?
Correct.
Okay. So how many months do you have then that you're requesting for missed rent?
Requesting 6 months total.
So that would be December of 23, January, February, March of 24,
Correct.
and the 2 missed payments from, was it 22?
22.
Okay.
Correct.
And how much was monthly rent?
Rent was $1,400 plus a $100 late fee.
So $1,500 a month. So that comes out to, what'd you get, $9,000? 1,500 times
Yes.
6.
$9,000.
Is that right? Yeah. Do you have copy of the lease?
I do. I need to exhibit it up here.
Oops, I don't know if you want me to see what you have there. I'll let you tell me when. Tell me when you're set.
I'm set. I'm sorry, late fee was only $50, so I'm $50 too much.
So you're $300 too much then,
Yep.
right? Should be $8,700 for your rent. So that's what you're requesting for rent for $8,700?
Yes.
What am I looking at there?
This is the first page of the lease agreement, and then it goes, it's for Josh and Brianna, and it had their previous address, it had my address at the time, phone number, and then all of the different, and signature.
I'm sorry.
Just all of the different terms and conditions
Okay,
of the lease.
go to the very end, please. So where did they sign?
They signed up higher.
Right. So who did you sue here?
I sued both Josh and Brianna, but Brianna's the one who actually signed for the lease, but they both live there.
So her significant other, partner, or husband was named Josh also?
Yes,
Okay. But he didn't sign the lease.
he did not sign the lease.
His name was Nissan also?
Correct. However, her name is no longer Nassan. She is since remarried.
All right, well, I'm not worried about that. But the only one that signed this lease was Brianna.
Correct.
Okay. All right, go back up to the beginning, please. So what did you do with the security deposit?
I still have it.
Okay. $1,400?
Correct.
Excuse me. Jen, do we want to print this out? Oh, can we print it out? Off that? Can we? If you hit print, does it pick up this computer? Who would pick this up?
I do not see a way to print it out.
Click on that square right there.
This one?
No, where it says Microsoft Print to PDF. Oh, those are your,
These are my options.
oh,
Yeah. There's save as PDF, print as PDF. The HP printer is my home printer at home. Which
all right. No, no. Okay. All right, so you're seeking $8,700. That's all right, don't worry about it.
Or you can email it to Amy, who can print it up for research. That'd be the easiest way to do it. Or to Jen. Email it to her.
Yeah, let's do that. So just mail it to Judge Culotta. All one word. At lakecounty.ohio.gov.
at Lake County.
lakecounty.ohio.gov. G-O-V. All one word.
Okay.
Let's see if I get it. Excuse me. I didn't even got anything yet. Did you spell Culotta right? C-U-L-O-T-T-A? I can't see that. Can you make that bigger at all?
Judge Culotta, Culotta at lakecounty.ohio.gov.
Okay, I should get it then. All right, we can move on. What else is it that you're seeking?
So I'm seeking damages to repair the house for the state they left it in. So this is pictures of,
Why don't you make that a little bigger? Just blow it up the top there.
um,
There, that's better.
so this is under the refrigerator, but that's, I mean, you can see the damage to the carpet as well as the wall, the hole in the wall. Every room has just clutter, and this is the garage with the floor. I had to actually get somebody out to unlock the garage because I couldn't even get into it.
So did they just leave and left all their stuff there,
They
or?
left just trash everywhere. This is the way they left everything. I mean, I had to do, there's 4 U-Haul runs.
There's 4 what?
There's 4 different U-Haul runs because I could only take a day or 2 at a time, which that's part of what I'm asking for is the missed time at work for having to use my PTO time to rehab this. So you can see all the black mold on the shower. I had to redo the shower.
How long were they there?
2021, March of 21 until March of 24, so 3 years.
And for until the end of 23, they at least timely paid their rent.
They were, yeah, up until November. Essentially, from what I understand, they were both kind of on the outs with each other and just kind of left the house. One moved to North Carolina, one moved to Michigan.
Okay. So, do you have anything you want to submit to the court in terms of a dollar amount you're seeking for repairs that you had to make and
Well, I had
expenses incurred in cleaning and all that stuff?
So I have all of the receipts and everything for everything. The total amount, it did include the missed rents though, so I would have to deduct that.
Well, just tell us what that total is. We can
The
deduct.
total was $18,204.49.
$18,204 and what?
49 cents.
And that included $9,000?
That included $9,000.
So then it'd be $9,204.
Correct.
And what does that $9,204 reflect?
It reflects the carpet and flooring is $4,751.45. 4 U-Haul runs ranging from $204.38 to $101.78.
What do you have there that you're looking at?
It's an Excel file of that just lists off all of the different.
If I looked at that, would I be able to understand what I was looking at?
Yeah, I mean, I have exactly.
Let's make a copy of that. A couple copies. Get one to, we'll mark that as an exhibit.
2 copies, sir.
Make 2. Get one for Jen too.
Yes, sir.
So those numbers on that Excel spreadsheet would be the $9,204
Correct.
in addition to the $9,000 for the missed rent.
Correct. I did ask on that Excel sheet for 20% interest, but obviously that's completely up to you guys. There was a separate line item for that as well.
That's part of the $9,204?
No, that would be in addition to that.
Okay. Let me just take a look at that, see if I have any questions about it. Aside from any expenses on that Excel spreadsheet, is there anything else you're seeking?
No.
So, I'm not saying you're going to get it, but the time off that you requested, that's a line item on that?
Yep.
Okay. I'm not sure you're entitled to that. I need to take a look. No, I got the lease. So we'll print that out. So you marked this one 1, the Excel spreadsheet 1?
Yes.
Okay. Let me see if I
Is
can,
that coming out here?
we'll see.
Oh,
I don't know.
I don't know if it's coming out in this one or.
I only got a button for quick print. I don't know what that is. I've never seen that before. Maybe if I open it. Oh,
Want to say quick?
something's coming up.
Yes. It's calibrating, so. Printing documents. No, it's not.
All right, well, here, that should work now.
You do quick prints.
I think it'll work now. This is good. We get a chance to use the stuff in here that we never use. If that doesn't work, I'll send it to the copier, but
Yeah, it's just sitting there saying ready, so.
I thought I sent it to the courtroom printer, but. Well, I just sent it to the copier. You can see if it's coming out there.
Okay, sir.
All right, let's take a look here.
It's coming out here.
So the PTO is obviously missed wages, right?
Correct.
Days you had to take off for. There's 3 charges there, the same amount. Is that like one day, or is that?
That's one day at a time for each pay period.
So,
So, and I
oh, there's 4 of them there. Well, one of them is $1,000.
yeah, the one was, I had taken multiple days off that week to
Okay.
finish everything in the house.
So the PTO is for missed time from work that you had to take to address these issues.
Correct.
And it looks like there's about $2,200 there, so. The U-Haul is what? What you had to rent a U-Haul to,
To get rid of their stuff.
okay. What's Joey's?
Joey's is
Lunch?
Is feeding my family
Okay.
while being at the house, since we didn't have refrigerator, like the
Okay.
refrigerator wasn't working.
And then the stores,
So
those are all,
those are all supplies to whether it's cleaning or replacing.
okay. What about Giant Eagle?
Again, I believe that was something to feed my family while working at the house.
What's Restore?
Restore is buying used doors instead of having to replace the doors that they had damaged.
What's Karen's?
Karen's is a pizza place to get, again, food for while
Okay.
working. That was how I was paying friends to help with some of the labor intensive stuff, was to feed them.
And then all the different stores are just things that you bought to cleaning supplies or stuff to replace stuff or fix stuff?
Correct.
So the missed payments should really be $1,450, correct?
Correct.
Okay. And I'm assuming you didn't return the security deposit.
I did not return the security deposit.
At the very end, your son says plus court cost.
Yes, if there's any court costs that we've incurred with filing and everything, I'd like
Well, costs, I mean, they'll have to be responsible for costs. You won't get billed those, but, okay.
Okay.
I mean, I won't, that's not part of the award, but you, he would get back whatever costs he put down, right? And then they would get billed, right? What money did you spend with the clerks?
Well,
Probably when you first filed, right?
yeah, it was, I think it was $300 to file, if I remember. The exact amount.
Well, if a case gets resolved and says cost of defendant, doesn't the plaintiff get that money back?
I
I
just
think
don't
you-
know how that works. I'm
I
sorry.
think that's how that will work, is
Okay.
once this case, once I do an entry awarding whatever it is I award, the entry will say cost to defendant. So I think that triggers the clerk's office to return any cost that you put down to you, and then they'll bill them that money.
Okay.
Well, Jen, you have any other questions here?
I was looking at the lease to see if there was an interest of 20% every year. So I think if there's not.
Right, we can talk about that.
The statutory interest.
Okay.
I believe it's about 8%.
Okay.
Yeah, unless a contract specifically addresses the issue of interest, then you're just entitled to statutory interest.
Okay.
Is there anything else?
What's the $9 charge for
Where's that?
AutoZone? It's just.
Oh, $9.11.
Yeah, it's.
I believe it was a specialty bulb, but I don't remember.
Specialty bulb.
I believe so. Let me look here. Yep, long life bulb, 2-pack.
Okay.
For one of the light bulbs that was out.
Anything else? All right, then we'll take the matter of advisement. We'll get an entry out probably in the next week or so, and I'll send that to you. And then at that point, the case will be concluded from our end, and you'll have to do whatever you can do to try to
Yes,
get it.
I'll have to find out how to
Yeah.
get it to Michigan and North Carolina.
All right.
Thank
Do
you.
you have any questions for us? Anything else you want to address or put on the record?
I don't think so.
All right. Thank you very much.
Thank you.
Okay.
All rise.